afternoon. Thank you for joining us for the COVID-19 Global Disruption Update focused in HR. We have come to our last week of our monthly long sessions. It has been a great time for us to put these together. Jeannie and I have really enjoyed this experience, and we look forward to presenting more training sessions in the future. Now, just a note, these slides are updated as of actually yesterday, so 4/20/2020, just in case you're referencing this recording session later. Now, speaking of recording, we are recording this webinar, and so if you do not want to participate in a recorded session, please exit the recording at this time. Now, I would also like to take a moment and share that we are not attorneys or tax accountants, and as such, none of the information we're sharing should be construed as legal or financial advice. We always encourage our businesses to consult those partners for guidance for their own organizations. On the line today from our team, we have myself, Amanda Erickson, and Jeannie Valier from HRX Services. Again, I'll be presenting content, and Jeannie will be working to moderate and facilitate the chat feature and questions and answers section of the webinar. Now, between the two of us, we hold certifications in PHR, SPHR, SHRM CP, and SHRM SCP designations. Jeannie, would you like to say hello?
Good afternoon. I am excited and sad. We're coming into our last week.
I know. It's kind of bittersweet, but it's been a great experience so far. We are also joined today by our colleague and friend, Mike Kohler, working through Elevate in the virtual series. Mike, would you like to take a moment to introduce yourself?
I want to mention I am the coordinator of the Elevate training program, which on the fly in the course of a few short weeks, we've converted to Elevate Virtual. We appreciate your participation, but more than that, we appreciate people like HRX Services and others in the Elevate program who have stepped up and have provided pro bono services for everyone during this crisis period. I am glad to announce that we're going to continue offering more of these services, so don't be surprised if we are in touch with you to get your views about how we can best serve you in the weeks ahead, because look, we know we're through one phase, potentially transitioning to another. So the rules of the game are going to keep changing, and we want to stay on top of that with you and for you. So you'll hear from us. And I won't do an embarrassing thing like mention that tomorrow is Earth Day, and it's another important day. But I won't sing happy birthday to Jeannie. I'll just hope to.
Oh, rough.
I love that. I love it. That's amazing. And it wasn't me, so that's even better. Well, thank you, Mike. Once again, we do appreciate the opportunity to connect, and this has been wonderful, even though we've all been social distancing, to have a little connection, so thank you. Let's go ahead and get started. So, a little housekeeping. Again, we're using the meeting function today, not the webinar. So things are going to look just a little bit different if you've been on sessions with us in the past. So just as a quick heads up. There's a chat feature at the bottom of your screen, which may be hidden, and you will need to use your mouse to pull up that toolbox just in case. Now, all attendees should be in listen-only mode, so there's no opportunity to unmute, and you will need to use this feature to ask questions directly. Jeannie will be managing the chat box and answer questions as we can, or bring to the group if we have some time or the question is pertinent to something we're discussing at that moment. If we don't get to your questions today, we will plan to address them on Thursday in our Q&A session. So I want to note at this time, if this is your first time on our webinars in this series, our format has been to host a Tuesday content-based series like the session you're in today, and a Thursday session for question and answer. We are hoping for some Q&A time always, but that is also what our Thursday session will be set up for. This Thursday, we're going to have Jeannie Valier once again, and Mike Kohler is going to work through our Q&A session as our guest, and that's fitting since it's our last session for the month. We will also be working through a lot of what we talked about today and addressing any questions we have then. So let's begin. So our agenda for today is really to focus in on some particular subject areas. We try to be focused if we can. We're going to walk through updates, the things that, again, we call it what we would want to know now type of items. We'll also discuss some important notes, things that we think you just should be keeping mindful as we're kind of readjusting and getting familiar with how this new normal is working. And then, of course, we really want to talk a little bit about the way back, like how are we going to start getting prepared for our next stages of COVID and how we're going to re-engage with our community. So just some of the focus areas that we're looking at for today. So as always, we want to bring you the newest updates, or again, things we would want to know now as HR professionals and leaders in our organization. Most of these updates in the next few slides are clarification points based on the FFCRA questions and answers link. We'll be providing a list of resources at the end of this session with the slide deck so you can review them in more detail at a later time. These new clarification points were pulled out predominantly because it addresses questions that we've received from our clients and partners and questions that we've received in these sessions earlier in the month. So you will see some of that. Additionally, we won't be reviewing how the paid sick leave and expanded FMLA works today. We've covered them pretty comprehensively, I think, in previous sessions. So if you're interested in reviewing those, we will be providing a link to our YouTube channel, HR Explained, that's the title of it, which has our 6 previous sessions available. So let's walk through some of the clarification points that we thought were interesting. First is a question on how we qualify overtime. So to determine what you would need to pay out of our employees, if our employees were to qualify for FFCRA leave for a COVID-related reason. So the first answer is yes, you do need to account for overtime hours if that's a typical situation for your employee. However, clarifications on the questions and answers would suggest that paying for hours over 40 would not to be paid out at a premium rate. That was one of the clarification points, which I take to assume that that means there's no need to pay time and a half on hours over 40. Jeannie, I don't know if you are still unmuted, but just curious if you would agree with that.
I would agree with that. I would absolutely agree.
Okay. Next up, commission pay. So we do have some clients who work with commission pay, and that's something that's been a little bit tricky to work through. You do need to calculate this amount at the rate that you're paying for the leaves. So again, that can be a calculation taking how much pay was paid out to an employee at a certain period of time and divided by how many hours they worked during that same period of time. There are some calculation examples that they provide in the question and answers. So this is something you're interested in learning and understanding further, then I would definitely encourage you to look at that Q&A for more specific details. Certainly, you're welcome to reach out to us or other partners in order to ask further questions on specific instances. For a temporary worker who's been hired onto the organization, so the question becomes, do I get credit for time served, right? And the answer to this is that you may count these hours toward your 30-day period in order to qualify for the expanded FMLA required 30-day eligibility period. So if you have been on site with an organization and they decide to convert you into a permanent employee with their team, then those hours that you had worked could qualify towards you being eligible for that leave. Now, how about if I pay people on a fixed salary? And Jeannie, I am going to ask for your thoughts on this too, so just kind of be listening. If I pay people on a fixed salary and we're not tracking hours. So I find this interesting because generally speaking, we would consider someone on salary as an exempt level person. Now, that's not always the case, but that's how we would kind of normally consider that. And you would pay out just what you would normally pay. However, in a circumstance that you're paying someone a certain amount per week and their hours may vary, you may need to calculate how much they've earned over 6 months and how many hours they have worked during that same time period, especially if they're a non-exempt salary paid employee. Then you can calculate your hourly cost. They also further clarify that if you lack records for the number of hours your employee worked, you should use a reasonable estimate. So I can see this maybe being more relevant if you're trying to determine an intermittent pay schedule for your employees in particular, so they're kind of working on and off with you. But I think, Jeannie, and I'm just assuming here, if this is how you're paying your employees generally, like you're paying them on a salary basis, but you're not tracking hours and they're in a non-exempt position, I think you may want to reach out to your HR partners just to ensure you're abiding by some other regular compensation rules as well. But for the most part, they do offer this, and I wanted to throw it in just because I found it interesting personally. Jeannie, any thoughts?
Lots of thoughts come to mind, absolutely. So I think just for the folks on the call, because I feel like we don't know everybody who's on, the Department of Labor looks at an employee predominantly two ways. They're exempt from overtime, and they're non-exempt, meaning they're eligible for any time and a half over 40 hours in a defined work week, or in Colorado, 12 hours in a day. There's this third variable that we've come up with in society, which is called salary non-exempt. And a lot of small businesses use that because they say, well, you know, we just want to pay them a standard set of hours, but they're really hourly employees. So what that means is if they work less than 40 hours, they're still going to be paid 40 hours. But if they work in excess of 40 hours, they'll be paid time and a half. And I've always asked businesses, well, when you do that, clearly you must be tracking because you know how to handle the excess piece, right? So in theory, you should know how to handle the less than 40-hour piece. And usually the answer I get is, not really. They tell us when they work more than 40, but not necessarily when they work less. So I agree. I think if you run into those scenarios, especially if you take someone who makes, for example, like $52,000, because that's an easy number, that's $1,000 a week gross wages. And if there is some variable hours, you want to look at that. I think that could be very costly if you make the assumption, well, we'll just pay them at 40, but if they've legitimately only been working 32, how do you go back and figure that out?
I would agree. So I think that there's like kind of more to this. There's a little more meat and potatoes in this particular situation. It is one of the questions and answers. I wanted to address it here just because, like I said, personally found it kind of interesting. But if you do have that type of situation where maybe you pay people on a salary basis, but they're not technically an exempt level position, then this would be something that would definitely potentially apply to you, especially if you aren't tracking hours all the time. Then they do kind of add some guidance and clarification points there as well. So just something to note. Additionally, policy compliance. So we know that we've seen a lot of different policies, a lot of changes happening, and excuse me, as some policies may need to have shifted in order to ensure that your policies are now in alignment with how this law is working and other laws, they do substantiate that it's okay to make those changes in order to be in compliance. So right now, I know that we've got a lot going on. Policy review may not be your number one priority, but it should be something that maybe you are looking at and considering. And as for this last piece, the definition of a child. So in this circumstance, we can see that the definition of a child, where they were always saying is, somebody under the age of 18, a son or a daughter. When we're looking at that, it really seems to now follow along, or the clarification is that they're really following along with what the FMLA would define as a child. And as far as bringing in the idea of in loco parentis, which generally is the meaning that a child would be someone who is consistently under your care and guardianship, could be then considered your child. At least that's usually how FMLA looks at it. So again, just some further clarification around some of those areas that might have been a little gray. Now, rounding numbers. So there have been some questions around being able to round on hours calculations. So for example, you might typically round to the quarter hour or the 10th of an hour or something like that. And the question was, okay, well, is this something that I can continue to do? And generally, this is acceptable for FFCRA calculations as long as you use the same method for all of the people. And I would venture a guess that it should also match what type of pay practices you are currently working through in your payroll system now. So just something to consider. And what if someone needs to leave, or they do have to take leave? How do I determine the pay rate if they need to take leave again in the future and have not exhausted all the leave available? So I'm in a circumstance where I take some leave now and then things are a little different and then I have to take some leave later. So I still have some opportunity for that. The Q&A shares specific clarification. They would use the same 6-month time period for all leave requests. So if you're figuring it out now, you would use that one for any leave in the future. You don't have to reassess what that looks like based on some of that changing dynamic. And lastly, if our school or daycare is open, but on an online basis, does this still qualify as closed for purposes for leave eligibility? And the answer to this question is yes. It's a little different than I'm working remotely, right? Could still qualify as active at work. It's not really the same principle here as far as your daycare or school. And so when you're looking at that, the answer to the question is if it's closed, as long as the physical location is closed as well. Okay, so what if an employee doesn't feel like their employer's in compliance? The DOL is also sharing guidance on this in the Q&A, which, just to keep in mind, is written both for employers and employees. I think strategically this can be viewed a little bit as almost a step-by-step suggested format, meaning if I don't think my employer is complying, I would engage in dialogue with my employer to discuss first and have a conversation. If that doesn't work, I'd be able to call the wage and hour division. And if needed, I can take my employer to court without speaking with the wage and hour division directly. That said, they do qualify that isn't necessarily the way you need to do it. So it's not needed to be done in that order. An employee could go immediately to taking their employer to court if it felt that, or if they felt that was the best course of action for them. Now, what does this mean generally? Well, I think we would encourage dialogue around this, and in the Q&A, it is highly encouraged throughout that employers and employees find some way to work through this time together. So employees want to stay engaged and continue to earn money, and employers want to be able to have their employees earning money and performing work. So for those reasons, the DOL suggests multiple times throughout the Q&A to allow for flexibility in how, when, and where the work is being done to be the best solutions for all parties involved. So again, just something to take into consideration as you're kind of navigating some of these. Okay, so let's continue moving forward. In this next section, we're going to talk about the important notes or things we think you can start or should be thinking about at this time. So as we start to turn to the more normalcy of life and navigating back to the workplace and back to being together, there's some important things to note and good reminders to have in general. First is from the EEOC. So as employers, is it okay to ask certain things? Or am I infringing on the rights of my employees? So the EEOC gives us some guidance. It says it is okay to ask certain things. You can ask, for example, if you're having any COVID-related symptoms. You can ask if they have been around anyone that has COVID-related symptoms or has tested positive for COVID. Now, I would not encourage you to ask specific questions about who that is that they may have been around for GINA reasons, with HIPAA, just some things that you're kind of really looking at that could be asking for personal health information that you don't necessarily need, unless they have said that they have experienced these symptoms and you are trying to find out for your work purposes who they have been around in order to notify those people about potential needs for isolation. So we're kind of in this really gray area, and I would just be very, very careful as you're navigating this. It is also okay to ask someone to leave if they are experiencing symptoms. So if you're keeping track of employee health information, you just need to be certain you're documenting it correctly and that your record keeping process remains confidential. So in this circumstance, like other health related information, these records should be kept separate from an employee's personnel file to limit exposure to sharing accidentally another person's personal health information or PHI. Additionally, taking temperature is something you can do at this time for COVID related reasons only. Although be aware this doesn't always provide 100% accuracy, as some patients, as we've come to learn, did not have a fever and still tested positive for COVID. but it can help mitigate the risk, and it is allowable. Now, if you choose to do this, again, a process for everyone should be put into place. Make sure you have the proper tools to avoid contamination, and make sure you're avoiding any type of discrimination, meaning you should really test everyone. If you're going to test some, test all. Having people's temps taken upon entry could be a great idea, but some thought into how you plan to do that. Who will be doing it? Are they qualified to do it? Where will they be doing it? And how you will ensure it is always happening is really important. And of course, if you do have some cases that are reported to you, reporting this to the proper agencies is important for all of us. And requesting a return to work is 100% okay. So all of those things are things to kind of start thinking about as we're navigating bringing people back into the workplace. Additionally, you will want to remain cognizant of requirements under areas that protect employees' rights. So reasonable accommodation includes things like making existing facilities accessible, job restructuring, part-time or modified work schedules, acquiring or modifying equipment, changing tests, training materials or policies, and providing qualified readers or interpreters. So that's kind of what the normal area is for some of those reasonable accommodations requests. For COVID-related needs, if not already implemented for all employees, accommodations for those who request reduced contact with others due to a disability may include changes to the work environment, such as designating one-way aisles, using plexiglass, tables, or other barriers to ensure minimum distances are being held between customers and coworkers wherever feasible. And this is per CDC guidance. Or any other accommodations that reduce chances of exposure that are reasonable for the employer to take into consideration. Flexibility by employers and employees is really important in determining if some accommodation is possible in these circumstances. Temporary job restructuring of marginal job duties, temporary transfers to different positions, or modifying a work schedule or shift assignment may also permit an individual with a disability to perform safely the essential functions of the job while reducing exposure to others in the workplace or while they're commuting to the workplace. So I know we've experienced some questions around this, so just really wanted to share exactly what we are seeing from the CDC, and some of that guidance is really verbatim from them. So let's talk a little bit about FMLA. So FMLA is usually for those, for those employers with 50 employees within 75 miles, work locations. And even though you may not have an FMLA related need for leave, it could still fall under ADA. And ADA is required for employers with 15 employees or more. And the need for interactive process and engaging in dialogue with employees is really, really important. Now, the EEOC will also say that discrimination based on certain criteria, but you need to be careful that even though the EEOC says, okay, you have to have 15 employees again for this to be applicable to you, the state of Colorado is not as lenient in that. They definitely say that for all employers through the Colorado Anti-Discrimination Act, that you are not to discriminate based on race, color, national origin, ancestry, creed, religion, sex, age, physical disability, mental disability, marriage to a coworker, which is some certain circumstances that you would need to be more in tune with if you have that situation in your workplace, and sexual orientation. So again, this covers all employers. And so while we're walking through these things, just how you're stepping through how to re-engage with people is going to be really important, that we don't step on any of these other rights. Okay. Let's talk a little bit about equal pay for equal work. So the Equal Pay for Equal Work Act, which applies to all employers in the state of Colorado and goes into effect, Jeannie, January 1, 2021?
That's correct.
Okay. It includes provisions on pay equity, pay history, and pay transparency. There are also additional requirements on promotional opportunities and compliance with wage rates. Employers must make reasonable efforts to announce, post, or make known all opportunities for promotion to all current employees on the same calendar day. And employers must disclose in each posting for each job opening either the hourly or salary compensation or a range of the hourly or salary compensation and a general description of all the benefits and other compensation offered. So again, this is something that is going to be coming to our workplaces. It is passed. This act is moving forward. And to our knowledge, January 1st is still the timeline for this for you to need to be in compliance with this law. Further talking about that, an employer can avoid some legal liability under the new law if it demonstrates that the entire difference in compensation is based on at least one of the following or on the following. So a seniority system, a merit-based system, a system that measures earning by quantity or quality of production. So you've got something there as far as how you're doing work product. Geography, the location of where the work is performed. Education, training, or experience level that could definitely be justified for why somebody might be paid a different salary than someone else. And travel. Travel can also be a consideration. So once again, you may have something like this in place, and this may be how you are really paying your people. But if you haven't done some type of compensation analysis or really looked at your compensation strategy as a whole, now would be the time to do that. Go ahead, Jeannie, I heard you.
I kind of want to jump in there because the Equal Pay law, or the Equal Pay Act of 1964 already encompasses a lot of this. It's not new per se. I think the thing that we as Coloradans should be really careful about is just to say that, you know, I have a seniority-based system. In other words, I hired someone 2 years ago and I hired this one last year. That is not enough to distinguish seniority. I think they're really going to scrutinize, do you have a formal plan in place? Same thing with a merit system to say, you know, I have a merit-based pay system. There should be some documentation backing up that merit pay system. They call this the safe harbor period, where people are having an opportunity to evaluate all of these items and to make sure that they have documentation to support all of these items. So I would just say not that you can check a box and say, well, you know what, because I have somebody on the eastern slope versus the western slope, I easily can pay one or the other higher. It's not as simple as that.
I would agree. You really do have to have some more salary information, some benchmarking proof, things that would really substantiate the reasoning behind why you have said that.
Agree.
One of the things that they've noted in some of the research and the work that we've seen is a successful plaintiff may recover up to 3 years of back pay and liquidated damages unless the employer can show that the act or omission giving rise to the pay violations was made in good faith. Again, something that they didn't intend to do, but in order to really kind of prove that good faith would require some additional work on the employer's part right now during that kind of, you know, gearing up time. So one of the things to ensure that you're doing what you should be, attorneys are suggesting the following areas to review. Practices regarding posting new job openings. The new law requires including a wage rate or a range with each new job opening. So also along with the general description of other benefits and the compensation offered. So if this isn't something you're doing now currently, it's going to be pretty easy for them to spot you if you post a position and you don't have a wage range posted with it come January 1. So something to consider. The new law also requires reasonable efforts to inform all current employees of promotional opportunities on the same calendar day, and policies and practices surrounding compensation. So more kind of what Jeannie was talking about. Employers should review hiring practices, avoid asking questions about compensation history of an applicant. So this is something that you can no longer do either. And employers may no longer require employees to sign a waiver that forbids the employee from discussing compensation information. And so this has kind of been something that has been in the works. To Jeannie's point, again, employees have had the opportunity, they've been protected to talk about wage in the past. However, this is now for kind of all positions. So even leadership roles and other areas where maybe you had a little more formality in that. The Colorado law does not forbid employers from asking employees, though, or applicants their salary expectations. So again, not asking what they made, but asking what they're looking to make is that differentiator. Additionally, there is some relief to litigation, as Jeannie was talking about, if an employer is demonstrating a true desire to audit and make right issues in their compensation practices. So again, if you want to make sure that you could qualify for kind of that good faith or some of that relief, then you do have to engage in some type of audit where you're reviewing your information, and then you have to be prepared to make changes if you do an audit to begin with. So just something to keep in mind. There is going to be an opportunity for us. We are hosting another webinar at the end of next week where we do have an attorney coming and speaking more in detail about all of these things. So if that is something you'd be interested in, certainly look for that. When we send out the information here, we'll have a link to that session as well. Now, as far as comps, so generally speaking, comps is the comps order 36 replaces prior minimum wage orders, which covered only 4 industries and expands, but this also expands Colorado overtime, meal and rest break requirements, as well as travel time requirements. Exemption tests, based on which positions would be considered exempt, and other rules to really all private employers. So before it hadn't been to everybody, but now really this affects all of us. One of the biggest changes that you're going to see here is based on this chart that we have, which is stating that, starting July 1 of 2020, your exemption level salary range has to be at $35,568, which, just for reference, is the federal guidelines right now. So as long as you're adhering to federal rules, then you're probably good for this year. However, please note that January 1 of 2021, that does increase about $5,000. And you'll see that increase $5,000 then over the next several years until it will adjust with the consumer price index going forward. This is something that did come into play, and comps is actually in effect as of March 16th. It's just the pay, the exemption level component of it doesn't need to be managed until January 1, as long as you're in compliance with the federal guidelines at this time. What does comp stand for? So Colorado overtime and minimum pay standards. This went into effect, like I said, March 16th, with salary benchmarks starting in July and changes above the federal level starting January 1. There are some exemptions to the rule, which include administrative employees, executives or supervisors, professional employees, and outside salespeople, which is just a little different than what we might be accustomed to. Now, again, we'll be providing the material in these slides, and we're hosting that other webinar more specifically geared toward this particular piece, so you can look at those in more detail at that time as well. Most significantly, if an employee is not authorized and permitted to take a required rest period, which in our last webinar, Jeannie did kind of bring up, and so I wanted to readdress here, Comps Order 36 states that the employee is entitled to 10 minutes of additional pay. So the Division of Labor Standards and Statistics has taken this position that a full additional 10 minutes of pay is required, even if the employee takes a shortened rest period. So for example, if an employee is called back to work 6 minutes into their rest period, the employer owes a 10 minutes of additional pay, not just the 6 that they didn't get. Now, important to note, if an employee voluntarily chooses to work during his or her rest period, additional pay is not required. Again, this is received from some of the attorneys that we follow. Employers are required to authorize or permit rest periods, but are not required to ensure they are taken. And you can also break it up. So you don't have to say you have 10 minutes here. You can do a 5-minute break here and a 5-minute break here, as long as the employee also agrees and both are on the same page. Once again, we are providing a more detailed session hosted by HRX Services with Colin Walker, who is a director and attorney at Fairfield and Woods, and that'll be next Friday. So take a look for that invitation coming your way. Okay, so now we've covered some things we would want to know, related updates, along with some important notes. Let's discuss a little more about the way back. How do we navigate back to where we came, or can we? Really, that's kind of that question, right? So in previous sessions, we've discussed Tuckman's model. I like Tuckman's model. It's simple to me, so it makes sense. But this one's specifically focusing on teams and the dynamics there. So again, remember, when we make changes, whether we're adding a new dynamic, like working from home, or we change our team by adding or removing team members, we are in a sense forming a new team. So we're in that forming stage. When that happens, we naturally grow through a storming period where we are trying to figure out how to work best together. We're bringing different dynamics in, creating a new environment that is definitely going to provide some storming areas. This causes that natural tension or conflict, which again does not have to be a bad thing, but we try to move quickly through this phase with good processes, good communication, and good workflows. We work toward getting toward the norming phase and trying to keep things moving in good fashion as quickly as we can. And if we can, we move into performing, where things are coming together. Progress is happening in high levels, and we really have what we call that high performing team. Now, from our conversations and the clients that we're working with, the people that we're connecting with, we are seeing people experiencing probably more of what we're calling the new normal. I mean, that's like a catchphrase, right? And we're all norming together. But once we shift back into changing that dynamic again by bringing people back into the workplace, we are now moving back into that forming stage. And we're working through that cycle again. So again, this is not a terrible process, nothing to be afraid of. This is pretty natural. It's just one thing we need to understand so that we can continue to change, adapt, and grow as teams and organizations. Also, I think we will probably be working through some version of this for a little bit, for a while, some time to come. I think none of us here really think that everyone will just be able to come back all at once, right? I think we've heard from the government, from our leaders, state, local, that that will not be the case. I personally, this is Amanda's, I'm thinking, could see some type of like staggered start, maybe bringing people back a couple of days a week, and we shift who comes back in so that people are kind of offsetting each other, staggering work shifts for people so not everyone is working in the office at the same time, maybe some work part of the week from home and some part of the week from the office. Or maybe in some circumstances, we've learned that remote work is good for our group and our organization, and our KPI, our key productivity indicators, are off the charts. And this becomes more of a new normal for us. All just things to consider as you're kind of trying to figure out how this will work best for your own organization. But let's say we need to rehire our team. We are looking to bring people back if we had furloughs or layoffs. Some things to consider. First, our compliance areas, right? If we hire people back, we can we ask about COVID-related symptoms? Can we put a job on hold if someone is experiencing symptoms? And according to the government, you can. You can also withdraw an offer to hire someone for a position that you need right away if someone is experiencing COVID symptoms. That is something you can do. However, we would encourage you to be very careful about how you work through your process here. Be sure not to discriminate against your higher risk folks, and be consistent in your decision-making process to avoid discrimination claims. Also, rehiring means just that. You're going to want to produce a new offer letter, something that allows people to understand what their new position would look like, as people may have been looking for another position while they've been out of work. They may not want to come back and work for you. You may have to change some salary terms, or start dates, and job descriptions might have shifted a little bit. So you really want to treat this almost like that new hire, so that you're giving them an opportunity to really see what that position looks like. All things, again, to consider and share when you're thinking about bringing people back into the workforce. Now, when you're doing that, consider some of the different aspects now that you have people coming back into the office. We need to review benefit changes. So, for example, do you need to collect premiums for people who are out on leave? How are your PTO and vacation/sick policies going to work? Are there new policies that have taken effect, such as comps, that people will need to be made aware of and sign off on? How about safety requirements? Do you have all of the safeguards in place you should and good communication around these items? Additionally, the state has just launched the Onward Colorado program, which offers training programs. Workforce centers are a part of this directive. Reskilling options and jobs and resources. This may be something you also want to take advantage of. These are just some questions to get you thinking about the things you may need to be considering and working through to put together for your own organization. Work with your HR teams, leadership, business owners, and partners to understand what model works best for your own organization. And remember, everyone is working through different stages right now based on their own circumstances. If we make some significant changes, this could shift again. And being prepared to help people through that will be really important and a key part of what HR can really be helpful in. So right now, I see a lot of people in this depression acceptance mode, even kind of moving like a week ago when we were talking about the stages of grief, when we were looking at it, I was seeing more people probably in that bargaining and depression area. But when I'm talking to people, that depression acceptance is kind of happening. I think we're seeing some ability to maintain some normalcy. But if you should change the dynamics by, say, moving people from remote work back into the office, that could impact people in different ways. For example, for someone who's been missing that inner connection and really wanting to be around people, and Jeannie and I were on a call for a board that we sit on where we were having that conversation, can't wait to get back, really excited, really want to connect and see people. We're excited. That's something that we're really looking forward to. But how about the people who really love working from home? Like, this is the best thing that's really happened to them as far as being able to work at home, have their own space, and that's worked really great for them. And maybe this is a great new norm. They can move back into that denial or anger phase pretty quickly if you start talking about needing to come back into the office. So what is important is to continue showing grace, establishing understanding as we help our teams navigate through this changing dynamic, and really develop some great communication and ways to circle back so that people can ask questions, get greater understanding, and move through that. Okay, now this brings us to teamwork and resources. So some of the resources for businesses include things like, we now are seeing not just SBA loans out there, but we are seeing and federal opportunity to have an opportunity for money from the federal side. We're seeing even cities jumping in and city-sponsored funding and really making sure that they're connecting with their local organizations and helping them to stay afloat during this time. Elevate, of course, we've got our Elevate training, and the fact that they just jumped into this and Mike got on top of this and was like, let's do a virtual series. Let's make sure that we're connecting with people still, even if we can't do our normal workshop routine, let's do it differently. Employee assistance programs, we still really see a lot of need for this, and people need a place where they can reach out and start to share how they're feeling and really get some good resources and a good start into maybe further sessions or further mental health and behavioral health types of programs that would be really helpful to them right now. And then business continuity plans. I know that Mike teaches some really great courses kind of in around thinking about how to manage through disaster. And I think that's the type of thing that you should be kind of thinking about. If we don't have a business continuity plan, right now is a good time to be thinking about one if you don't have one. But overall, we hope to cover a lot of this also on Thursday, because we're going to have Mike there, and he is really in that development and training space. And I think that as we're shuffling people back, that's going to be a really great opportunity to help us reconnect with people in that way. On Thursday, we'll handle some of that Q&A as we work through the session around how we do consider training and development and how we adapt, and what are the areas that I should be looking at further, as well as answering whatever lingering questions you may have. So if you haven't signed up for that session, I would encourage you to do so. It's kind of fun. I think we enjoy it the most. So we appreciate the opportunity to connect with you. I do want to see if we have any lingering questions, Jeannie.
We do not.
Okay,
First
great.
time.
Okay, that's okay. So I do appreciate that. The opportunity to connect with you once more. I'd like to remind you that we are recording this session, so everyone will receive a copy of the presentation as well as the slides, which includes links to resources we have available. Thank you to Jeannie and Mike for being my partners once again in this effort. Couldn't do it without you, wouldn't want to. Anything to add from either of you?
No, I think you've covered everything.
Great.
I do too, and I appreciate the mention of the highly interactive workshop next week on the 28th about business continuity. So, gee, there's a chance you'll hear from me.
That's wonderful. Thank you again. As a reminder, just our last little disclaimer here, we are not attorneys or tax accountants, and nothing we're providing should be construed as legal or financial advice. We really appreciate you joining us today. Thank you once again, and we will see you hopefully on Thursday. Thank you.